CR 509. Amber Norris appearing for the state of Kansas. Chris O'Hara as defense counsel. Defendant Salter now appearing at the Butler County Judicial Center Zoom location. This matter comes before the court at this time for further proceedings. The court's docket notes from May 16th, last Friday, indicating that the defendant had appeared by Zoom very late by his own Zoom. Chris O'Hara had appeared on time as his counsel. During a breakout session, a plea agreement was worked out in principle, but the defendant did not return to the meeting. The court suspended defendant's bond, bench warrant to issue with a no bond hold. Defendant did not appear at his attorney's office as previously ordered by this court. The case was then taken off the jury trial docket. What announcement is made at this time, Mr. O'Hara?
Your Honor, Mr. Salter would like to proceed with the plea agreement that was offered by the state. He would like to accept the agreement and enter no contest plea pursuant to that agreement.
All right, what is the remainder of this plea agreement, Mr. O'Hara?
Well, it's to an attempted count one, but it would be under KSA 215412 B3 C1 E4. An attempt which would be a level 8. He'd be pleading no contest to that and pleading no contest then to counts 3 and 4, and the remaining counts would be dismissed. And there's an agreement that the state, if the defendant could show he was, attending outpatient treatment, attending the treatment he was supposed to be attending, and his progress with that, and show he was doing well, obviously up to the point of sentencing, that the state would recommend a dispositional departure at the time of sentencing.
It is expected then that his criminal history would be such that he'd be presumptive prison here?
Yes.
All right. Very well then. I'll ask the state's attorney, has Mr. O'Hara announced consistently with your understanding as to how this Salter case would be handled?
Your Honor, basically, I just would make a correction on the ag assault. C1 basically makes it a county or city law enforcement officer, and then D3 is the basically how it was committed, and with the intent to commit any felony is the theory that we are going under, and then E4 would be the penalty section that makes this a person felony. And Your Honor, that is the agreement.
All right. So there's going to be an amended charging document here which changes the nature of the charge in count one?
Yes, Your Honor, it would be amended to attempt, which will make it a level 8. And then it will take out the deadly weapon, and basically that this was committed with intent to commit any felony. And the flee and elude, which is in count 2, would be that felony.
All right, Mr. Salter, you've been present when the attorneys have made their announcements regarding your case this morning. Is it indeed your intention to enter no contest pleas and accept conviction for attempted aggravated assault, a level 8 felony, apparently count 3, battery against a law enforcement officer, a class A person misdemeanor, and count 4, driving while license is suspended or canceled, a class B misdemeanor?
Yes, sir.
I have a number of questions I need to ask you regarding the taking of a felony plea in this case. If there is any question asked of you that you do not fully understand, I will give you the opportunity to confer privately with your lawyer to get further advice along the way. Just let the court know if you need that time to meet with your attorney again, okay?
Yes, sir.
State your full legal name for the record.
David Andrew Salter Jr.,
How old are you right now?
41,
What's the highest level of education that you've attained?
a sophomore, high school.
All right. Do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here this morning?
No, sir.
Have you ever been adjudged to be mentally ill?
No, sir.
Are you currently under the influence of alcohol or any drug?
No, sir.
Are you currently taking any type of prescription medication?
No, sir.
Are you supposed to be taking any mental health medications that you are not currently taking?
No, sir.
All right. So do you believe, Mr. Salter, as you sit today, your mind is clear and that you have a full understanding of what's going on in court?
Yes, sir.
All right. Obviously, there is no current charging document before you. Do you understand the nature of the charge of attempted aggravated assault as the attorneys have discussed its amendment here this morning?
Yes, sir.
You understand that when you enter a plea of no contest, you are not admitting that you committed this act or these acts that are charged by the state, but you would be convicted because you're not contesting conviction just the same as a guilty plea. Do you understand that?
Yes, sir.
All right. You also understand that when you enter a plea of no contest, you give up any legal defenses that you might have had to these charges.
Yes, sir.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses at your trial with the assistance of your lawyer, Mr. O'Hara, and that you could present evidence at your trial on your own behalf and subpoena your own witnesses to court?
Yes, sir.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that if you wanted to testify in your case under oath, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes, sir.
You understand, Mr. Salter, that when you enter pleas of no contest, you give up these valuable trial rights that the court has described.
Yes, sir.
You also understand that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt.
Yes, sir.
You understand that when you enter a plea of no contest, you give up your right to a trial by jury and that requirement that you be found guilty beyond a reasonable doubt.
Yes, sir.
You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes, sir.
You further understand that you may appeal your sentence after entering a plea of no contest, but generally, you may not appeal your judgment of conviction after you enter such a plea.
Yes, sir.
Now, are you aware of the possible sentence that could be imposed as a result of these no contest pleas that you are attempting to make?
Yes, sir.
Okay, we're going to go over those. A level 8 non-drug crime, such as attempted aggravated assault, under the Kansas Sentencing Guidelines Act, non-drug offense grid, in the most favorable criminal history category of I, you could receive as little as a 7-month prison sentence. However, in the worst criminal history category of A, you could receive up to a 23-month sentence. So the sentencing range is 7 to 23 months in prison, depending on your criminal history. As you sit today, Mr. Salter, we do not know with absolute certainty what your criminal history is. You, better than any other participant, really should know what your own criminal record looks like, but that will be researched by the Court Services Department, and based on the outcome of their research as of the date of sentencing, that will determine where you fall along the level 8 line, and then you'll be sentenced accordingly. You understand that?
Yes, sir.
You also understand that if you have 2 or more person felonies on your record at time of sentencing, you would be presumptive prison in this case.
Yes, sir.
All right. You also understand that you could receive up to a $100,000 fine for this offense.
Yes, sir.
I think that there was some mention earlier about a departure sentence. Do you understand what a departure sentence is?
Yes, sir.
A departure sentence would be a request made by one of the parties not to follow the general presumption under the grid, such as if you had 2 or more person felonies on your record at time of sentencing, your attorney could seek what's called a dispositional departure, which is asking the court, upon a finding of substantial and compelling reasons, to grant you the exception of probation rather than the presumption of prison. So do you understand what a departure would be?
Yes, sir.
All right. You understand that a departure decision, whether it be durational or dispositional, would be a matter of discretion for this court.
Yes, sir.
All right. All right, regarding count 3. An offense of battery against a law enforcement officer. That's a Class A misdemeanor, punishable by up to 6 months in the county jail and up to a $1,000 fine or both. Do you understand that?
Yes, sir.
Count 4 is driving while license is suspended or canceled, a Class B non-person misdemeanor. That has a minimum fine of $100 and a maximum fine of $1,000 and at least a 5-day jail sentence and up to a 6 months jail sentence attached to a conviction for that offense. Do you understand that?
Yes, sir.
All right. In addition to any fines that could be imposed in this case, you understand, Mr. Salter, that you could be assessed and be required to pay court costs, certain fees, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes, sir.
Do you also realize, as a direct consequence of this plea, you may be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you serve after you get out of prison, as deemed appropriate by the court at time of sentencing?
Yeah. Oh, yes, sir.
All right. Salter, do you understand that Kansas Sentencing Guidelines Act contains special sentencing rules? Do you understand that if any special rules apply to you and your situation, it could affect your eligibility for probation or otherwise affect your sentence? Do you understand that?
Yes, sir.
Do you understand the difference between concurrent and consecutive sentencing?
Yes, sir.
Concurrent sentencing means that the counts run all at the same time, which obviously results in a lesser amount of time served. A consecutive sentence is boxguard, back to back. You'd serve all of one charge before you start serving the other. Generally, Mr. Salter, it's up to the court to determine whether your counts or even certain cases run consecutively or concurrently. You understand that?
Yes, sir.
Now, have you had an ample opportunity to discuss legal matters like this with your attorney, Mr. O'Hara, before proceeding here today?
Yes, sir.
You want any more time with him privately now before we go any further?
No, sir.
Are you satisfied with the services and advice given to you by Chris O'Hara?
Yes, sir.
Now, Mr. Salter, this no contest plea, has it been based upon any threat or promises as to what this court will do in regards to your sentence, or any other type of threat or promise?
No, sir.
You understand that if there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, sir.
So let me ask you, how do you formally plead to this amended count 1, attempted aggravated assault, a level 8 felony?
No contest.
All right. And to count 3, battery against a law enforcement officer, a Class A person misdemeanor?
No contest.
And count 4, driving while license is suspended or canceled, a Class B misdemeanor.
No contest.
Court will ask the state's attorney to provide a concise factual basis for each one of these 3 charges.
Your Honor, on November 6, 2024, in Andover, Butler County, Kansas, the defendant was driving and was the sole occupant of a vehicle where he basically appeared to have fallen asleep, passed out at a stoplight, and law enforcement did make contact. Sergeant Snedeker had his hand on the window and basically they were trying to get the defendant to understand that he was now in a car stop and that he could not leave. Instead of following the instructions, the defendant put the car in drive and fled from law enforcement. And at the time, Officer Snedeker was holding on basically on the passenger side to the basically the pillar between the front and the back doors, windows, and was drug some feet, well, basically was, I guess, kind of walking, running beside the car, and then did fall and was slightly battered during this process. And the defendant, like I said, was fleeing from the traffic stop. And Sergeant Snedeker was in the scope of his duty. He was on duty at the time. And he did believe that he was going to be harmed based on the situation and having to kind of, basically run alongside the car as the defendant was pulling away. And Your Honor, the defendant was driving and had a suspended driver's license through the state of Kansas at the time.
Very well. Thank you, Ms. Norris. So, Mr. Salter, are you now making a plea of no contest and accepting conviction for attempted aggravated assault of a law enforcement officer as charged in count 1? Entering a no contest plea freely and voluntarily to count 3, battery of a law enforcement officer, a Class A misdemeanor, and count 4, driving while license is suspended or canceled, a Class B misdemeanor?
No contest?
Yes. And you're doing this freely and voluntarily?
Yes, sir.
Mr. O'Hara, do you know of any legal reason why the court should not accept your client's pleas here today?
No, Your Honor.
Ms. Norris, are you aware of any such legal reason?
No, Your Honor.
Mr. Salter, do you know of any legal reason or any other good reason why the court shouldn't accept your pleas here today?
No, sir.
Court will accept the 3 no contest pleas made by this defendant and judges the defendant therefore convicted of the offenses of attempted aggravated assault of a law enforcement officer, a level 8 person felony in count 1. Count 3, battery against a law enforcement officer, a Class A person misdemeanor in count 3. And count 4, driving while license is suspended or canceled, a Class B non-person misdemeanor. All other charges of the charging document are dismissed pursuant to plea agreement. Court orders a pre-sentence report be completed to determine accurately this defendant's criminal history. The court will set an appropriate date for sentencing. Mr. O'Hara, I will suggest Monday, July 21, 4:00 p.m.
That's fine, Your Honor.
Sentencing will be set in the Salter case for Monday, July 21, 4:00 p.m. All right. Mr. O'Hara, are you asking this court to readdress the issue of Mr. Salter's bond status,
Yes, Your Honor.
despite the fact that he showed up late yet again today?
Yes, Your Honor.
And the reason why he showed up late again?
It was my understanding he had transportation issues to get here because he's not able to drive, and that he had a sick child.
What's the state's position on Mr. Salter's bond status between now and time of sentencing?
Your Honor, he has previously appeared up and so I'd leave it to court's discretion.
All right. Mr. Salter, I thought your actions on Friday were abysmal. You were not where you were supposed to be. You couldn't handle the Zoom properly. You were moving around on camera in a sleeveless shirt, showing nothing but disrespect for the entire process. That led to an eventual order from this court essentially suspending your bond and requiring you to appear essentially whenever we could get you rescheduled. Now, due to efforts made by your attorney, he's asked for this special setting that we worked into our calendar today to accommodate you and not have you picked up on this arrest warrant. You have appeared, though you appeared late today, which I'm not happy about, Mr. Salter. Makes me wonder if you're ever going to appear on time for anything connected with the court.
I apologize. Our daughter was sick today, and it's hard for me to get around because I can't drive. So, I apologize. So
You had mentioned on Friday that you have a job. Where do you work?
I work for subcontract. We do contracting through TaylorMade, Woodridge, just simple siding, roofing, windows.
Probably busy right now.
Yeah. Oh yeah.
I don't want that interfering with anything else you still need to do. Mr. Salter, I think only because of the extraordinary efforts of your attorney to get you back into court promptly, the court's going to be inclined to go ahead and remove its suspension order and keep you on bond between now and time of sentencing.
Mhm.
I'd rather have you out there working,
Thank you.
gainfully employed, than sitting in the jail. But
Thank you,
here's what
sir.
I'm worried about. You may be requested by the Court Services Department as part of the pre-sentence process to perform one or more assessments. You're
Okay.
going to need to comply with those assessments. It could be a risk needs assessment. There could be also a separate substance abuse assessment. And you are ordered by this court to fully comply with those so that there's no delays in your sentencing proceeding, Mr. Salter. So Mr. O'Hara will take you by the probation department just as soon as we get done from court. And then you can check in with court services and they'll give you further direction about what you need to do next.
Okay.
And then I want you to appear at the same location you did today at the Butler County Judicial Center in El Dorado, Kansas for your sentencing proceeding. This will be a Zoom proceeding, so it's up to Mr. O'Hara where he personally wishes to appear from. But you, Mr. Salter, need to be at the Judicial Center in El Dorado, Kansas, and no other location for sentencing. Any
Yes,
question
sir.
about that?
No, sir.
So again, the court reiterates that its bond suspension order of Friday is lifted. And I'm reinstating the original bond of Mr. Salter with the additional conditions that he comply with the pre-sentence investigation report and its assessments, and to appear at the Butler County Judicial Center for sentencing as the court is ordered for Monday, July 21st, 4:00 p.m. for sentencing in his case. All right. Mr. O'Hara, are you aware of other case-related matters that we need to address at this time?
No, Your Honor.
Ms. Norris, anything further from your perspective?
No, Your Honor.
All right. Mr. Salter, you have any questions about what we've done here today?
No, sir.
All right. Again, Mr. O'Hara will take you over to the probation offices. It's just a short distance from where I perceive where you are in the building. And go ahead and follow their direction about scheduling in your case, okay?
Yes, sir.
All right. If there's nothing further then in the Salter matter, that matter will be in recess at this time, and this meeting may be ended for all.